here. I've been arbitrating at the Vis Moot, so I've seen some of you in action already this week. So congratulations. And I'm super excited to welcome you to a groundbreaking experiment today, which you will witness tonight, which is where ChatGPT will be the tribunal arbitrating these fantastic human advocates. So just a little bit about Canada. We are a leading independent Hong Kong practice, and I'm part of the arbitration team as well as in restructuring and insolvency. And I think our founder Ian Witt of Canada is here tonight as well. And we have a fantastic tech practice which is led by Patrick Walsh and Douglas Clark. So we're very, very happy to have you here. What I plan to do is to give the opening technical briefing. So I'm planning to cover just 4 topics. One is to just explain a little bit about what generative AI is, what like I would know, and then talk about the limitations of artificial intelligence in the law, something I just learned much more about, and the impetus for regulating the use of AI and its possibilities in terms of legal decision making. So turning first to what is generative AI, I think that the definition of AI is contested. All of you will be familiar with ChatGPT, a large language model. The way I like to understand it is that it's a computer system that can analyze vast amounts of information and provide some analysis and summaries and create content. And in the context of legal decision making, what we're seeing is that ChatGPT is able to do things like produce first drafts, or in the disputes context of disputes documents or first drafts of contracts, or it can analyze material for you. And actually, hopefully tonight we will see ChatGPT analyzing the Vis Moot problem from last year. And since OpenAI created ChatGPT, has really taken the world by storm, and I'm someone who uses it a lot as well. But of course, and this leads to my second point, there are a lot of limitations with using AI in legal work, and some of these risks can be categorized in 3 ways. One are the moral risks. So everybody's heard now of the infamous New York lawyer who relied on ChatGPT, which created some fictitious legal precedent, and that person actually relied on it in court. Unfortunately, that is not the only example where we have seen lawyers relying on fake precedents, and this has sparked a discussion about whether we need disclosure of AI-assisted work products in legal proceedings, whether that is in litigation or arbitration. This is not limited to legal authorities, but we're potentially confronting things like deep fakes and other types of legal evidence where it's very, very difficult for a lay person or even an expert to know whether evidence is being fabricated. Obviously, this is not the first time. We've confronted fraud and corruption in legal proceedings for a long time, but potentially the ease with which we can fabricate evidence and the difficulty of determining whether evidence is fake or not is becoming much more difficult, and this poses new challenges in the legal process. And then there are the legal risks. For example, I don't know how many of you have read the privacy and data protection policies when you're using ChatGPT, but there is a real concern about uploading confidential client data onto public GPTs. What we have seen is some law firms have adopted programs like Harvey, for example, where they have kind of closed circuits where you are able to upload or use these ChatGPT or confidential client data. And we're seeing issues with like data privacy breaches and confidentiality. And then there are the technical risks, which is simply, it's really hard to explain what AI is. There's what's called the black box problem. You can't see how an AI is reaching its decision, and even the people who designed the LLM models don't know exactly how it gets to its output. Yet that's a real problem in international arbitration as a legal proceeding, because the right to have your disputes resolved by a decision maker is that you expect them to tell you how they reach their decision, And if they don't give you sufficient reasons for their decision, you can actually challenge that in a court of law and say that your due process right haven't been properly protected. So what does this mean in an arbitration context when you have very many actors who may use LLM models and GPTs in ways that we can't explain? And then there's also hallucination, of course, fictitious precedents and things like that. And so that leads to my third point, which is the impetus for regulation of AI in international arbitration or in international legal proceedings. Now, I'm myself an arbitration specialist, and it's inherent in my practice that you have people who come from all different legal traditions. You know, in fact, today I think we have teams from Hong Kong, teams from Germany, you know, an arbitrator from Brazil, Mariel from Australia, and Germany. So there's this real like clash of different cultures. And so how do we level the playing field for those who are using AI? And what we've seen already in the BCLP 2023 survey is that, you know, overwhelming majority of the people who responded to that survey, about 200 people, said that there should be some form of regulation. But the devil is in the details. You know, one of the thorniest issues is disclosure. You know, if you use ChatGPT or you use any kind of LLM, do you have to disclose that? You know, how comfortable would you be if our tribunal tonight delivered an award that it used mostly ChatGPT to do the writing for, even if there was human verification of it? For my part, I've been working with the Silicon Valley Mediation Arbitration Center, where we've produced, I think, the world's first set of guidelines on using AI in international arbitration, where we hope to set out some best practice principles that will both allow us to leverage what is best about this technology while ensuring its responsible and ethical use. And then last but not least, the big show tonight, which is, well, how about using AI in legal decision-making? Of course, this isn't new. You know, many jurisdictions like China, you know, the UK, Pakistan, like we've already seen examples of robots being used in legal proceedings to do things like assist with research or summarizing materials for a decision, or making decisions or assisting with decision-making in specific contexts. We have seen the use of artificial intelligence in regulatory, by different regulatory authorities, where they're using it, for example, to spot competitive conduct in the competition law context. But in international arbitration, you know, if you have followed it, it's already very controversial to use a human assistant called a tribunal secretary. And so we might be seeing similar problems arise in the AI context, where judges or arbitrators are using ChatGPT to assist. So what is the capability of AI to make legal decision makings, and how comfortable are we with it? That's what we're going to witness tonight. So this brings me to say, to thank very much Cesar and your team in Brazil for organizing this brilliant experiment, and to thank the TDW team, so Harsh and Georgina and Felicia and others for hosting this wonderful venue. And Mariel, who is our presiding arbitrator with her wing robot. And also our thanks to our mooters as well. And our thanks to you for joining. So thank you very much and enjoy.
Thank you, Lizzie. My name is Cesar Pereira. I'm here on behalf of the Chartered Institute of Arbitrators Brazil branch. And I'm, first of all, very happy to say that we have here with us Professor Napoleão Casado Filho, who is the chair. Napoleão, where are you? Here, over there. Napoleão Casado Filho is the chair of the Brazil branch of the Chartered Institute. Brazil, as you know, is far away from here, but we are really excited to be able to hold here in Hong Kong this first experiment of ChatGPT as the arbitrator in this context of Vis Moot. Before I continue, I would like to express my deepest gratitude to Luísa, to Thunder David, and to its incredible team, Georgina, Felicia, and everyone, and for hosting us tonight. This is absolutely brilliant. We couldn't have a better setup for this experiment. We have been able to do some practice rounds this week, also due to the generosity of TWG, and so this is really wonderful. Last year, at the Chartered Institute of Arbitrators Brazil branch, we did something slightly different. We had a panel, a human panel, comprised of David Hübner, Sophie Nappert, and Louise Barrington, and they arbitrated one human team who had won one of the most important Brazilian freebooks, and a team of actors instructed by ChatGPT. If you're curious, you can take a look online. It's available on YouTube, and you can see how that went. For this year, we had the idea of changing it a little bit, and we asked ourselves the title question of this event: what if the arbitrator is ChatGPT? Last year in October already, we contacted the Vis Moot directors, who were also very thrilled by this idea, and we developed how this could work, how we could have a ChatGPT as a Vis Moot arbitrator. Vis Moot is very important for this, I think, in terms of allowing these types of experiments, because it's a contained setting in which you have a problem that's designed to be used for assessing the performance of the teams. And so, unlike a real problem that has other complexities, this one is thought specifically for that purpose. And so, it's a very good material for this type of experiment. And as you can imagine, there is a lot of work that goes into this. I would say maybe advancing part of what can be a discussion about the use of AI in dispute resolution and in advocacy in general. It's a lot less work than what these guys go through, and many of you go through, to prepare for Vis East or for Vis Moot. It didn't take 6 months of preparation and many pre-moots and many hours and nights of practice to get ChatGPT ready. Not last year and not this year. But even so, there was a lot of work involved, and I would like to thank very much my colleagues from the Chartered Institute in Brazil, from Justen, Pereira, Oliveira, Talamini. First of all, Luísa Quintão, who is junior partner at Justen, Pereira, Oliveira, Talamini in São Paulo, is the prompt engineer of the other co-arbitrator, ChatGPT co-arbitrator, and also André Gustavo Cardoso, Fernanda Romero, Douglas Amorim, and Leonardo Souza McMurtry. All of them are what we call the ChatGPT team that's behind this experiment. And also, I could not refrain from thanking and expressing also my gratitude to the Vis Moot directors whose vision has allowed this experiment to take place here at Vis East in Hong Kong, and also in Vienna later this month on the 27th of March, between the universities of Vienna and the universities of Vienna and Belgrade, who, as you may remember, did the final last year in Vienna. I thank also Mariel, our presiding arbitrator tonight, I hope, as we were discussing before, that, I'm sure we are all rooting for that here. I hope we will come to the conclusion that ChatGPT is not really there yet. So we're not risking our jobs so soon. But it's wonderful to have a chair on this tribunal of Mariel's stature and caliber. And finally, last but not least, I would like to thank our bold Moody's Echo Jane from the University of Hong Kong, Yanis Witt from Albert Ludwigs University Freiburg, Tino Wasner from the University of Mannheim, and Yongwen Tseng from Shenzhen University. As you see, what we try to do here is to have, as Luísa mentioned, a very diverse, geographically even diverse group of movies. They are not part of the same teams. They came together this week and took time from their activities here during Vis East to become involved and help us in this experiment. I will tell you very briefly about how this is going to work. I see in here that you're already very silent, which is going to be very important because our machines will hear and under a speech-to-text application will turn into text what our speakers will say. So it's very important for you all to be silent so that there will be no disruption. As you may already know, if you have played with ChatGPT a little, ChatGPT works basically upon prompts. That's why we call the people who talk with ChatGPT prompt engineers, right? Because if you ask stupid question, you probably get a stupid answer. And it's almost a training for cross-examination when you talk or when you prompt ChatGPT, because you ask something and the answer comes completely off. And then you ask it a little differently, and you see that it improves a little. And so that's a good exercise anyway. But you will see that what you see here on my back is my computer, which is one of our co-arbitrator ChatGPTs. We call it arbitrator Trinity. It's actually and Luísa has arbitrator Neo. As you may recall, this all comes from Matrix, which is an idea of our colleague Leonardo Souza McMurtry back in Brazil and the UK. And so arbitrator Trinity was trained. I don't know if you know you can do that, but you can actually customize GPT on ChatGPT, and it was trained. Oops, sorry. Do you remember how we did over here? Yes. Okay. So arbitrator Trinity was trained here very proficiently by Fernanda Romero back in Brazil, with instructions on how to behave. So evaluate arguments, ask for clarifications. You should always refer to the facts of the case law, scholarly opinions. When possible, be witty. Then some background information. And so basically some instructions on how the arbitrator should judge the pleadings, and what are the topics of for discussion and all that. And in addition to that, you can, in this one, this has been done, you can upload materials to comprise the knowledge of this GPT called 30th Moot Arbitrator. And here there are some secretariat commentary, some of the memos, and advisory council opinion, and other similar materials. So this GPT is supposedly equipped with all this. Now, Neo, Luísa's GPT, has only received the problem. Okay, and so in that booklet that you got, you know, with the legal sources, it received that as well. And so we will be able to see if that makes any difference. We don't know really. We have done some practice, but just like when you run a marathon, you don't. If you have ever done that, you don't run a marathon to practice. You just run up to like 30K, and you only know what happens when you actually run the marathon. And so this is pretty much what we're doing here. We did some small practices, but we have no idea if this is going to work or not. And you'll be witnesses of that. So without, do you have anything to add?
No, absolutely not.
Jesus.
Yeah. Well, we've encountered some difficulties, and I think that what we're not going to be able to show you immediately is that even though Neo and Trinity are all based on the same technology, we're using the same app, same extension, even though one has received a little more information from the speech to text technology to even how it answers questions. The two arbitrators diverse. They really dig in personality, even though they were both told to be witty, but apparently only Trinity is a little bit. And they hear differently too. So they're hearing the same people using the same app, and sometimes obviously I don't know if this is going to show here, maybe I'm ruining the fun for you, but I will give you this, and just as a spoiler. Honorable tribunal can also be a vulnerable tribunal. and yeah, so expect some things to be really not the as we would like them to be, but yeah, again, as Cesar said, that works in our favor as lawyers now, especially as arbitrators.
Yeah, so I think we can start our experiment. And for that, I turn the floor now to our chair. And good luck to our teams. We are rooting for the units.
Good evening, everyone. My name is Mariel Dimsey. First of all, thank you very much to Cesar for inviting me to do this today. I was a mootie myself. I competed in the 8th moot in Vienna in 2001. And you can no doubt imagine back then AI, and I mean, the internet was barely there, but certainly what we're doing tonight, no one would have even imagined. And when Cesar invited me to do this, I said, what do I need to prepare? And he said nothing. To his word, and apart from having a very busy week, I have tongue in entirely cold. So I am as curious as he is. And I personally, and I've been asked this quite a few times recently, I personally believe that there is a human element to decision-making that an AI program cannot replace. So let's see if tonight's experiment will prove me right or wrong. So without further ado, I think we should get into it. And with that, I will declare the current proceedings open. I'm assuming I'm not asking my co-arbitrators to introduce themselves, but I will ask the teams. Are you speaking for claimant?
Yes.
Okay.
Procedure.
So could you please introduce yourselves?
Sure. My name is Tako Chen. I'm from the University of Hong Kong, and I will be presenting the claimant's procedure ground.
And your colleague?
My name is Zhong Wen. I'm from Shenzhen University, and local counsel will represent claimant. I will deal with the merits issue.
Thank you very much, counsel. Counsel for respondent.
Hello, good evening to everyone. My name is Jan Swekler. I was participating last year for the University of Freiburg in Germany. This year, I'm coaching a team from Kazakhstan, Witt University. Probably I can announce that it was the first team from Kazakhstan who made it to the elimination rounds this year. And I'm happy to
my name is Tino Wasner. I'm from the University of Mannheim, which I participated last year for, and I'm coaching this year. And it's a pleasure to be here sitting now again in front of our last game.
Thank you very much, Council. I understand also that the parties have reached an agreement on how they would like to conduct this procedure. Could you please inform me of that agreement?
Yes, indeed. We agreed that the respondent is going to start on the procedural issues, followed by the claimant, and then the claimant is going to commence on the merits, followed by respondent. In case we did not specify a time allocation, and we will drop the rebuttal and so rebuttal to the submissions.
And I understand that this has been agreed.
Yes, and also parties have agreed on issue 2 and issue 4, so we're only focusing on issue 1 for tonight.
How efficient you will be in your client. So, Council, without further ado, I understand that respondent is starting on the procedural point, so I will hand the floor over.
Madam Chair, I just have one
Oh, yes, please.
question for you will see now my first prompt, which is this. Okay, this basically instructs what this arbitrator will do. We'll hear both parties, the issues, which are the ones that have not been agreed by the parties, and in what will happen here in order. And as you will see as we progress, that I will keep giving other prompts, and then we'll hear from ChatGPT as well. Back to you,
Wonderful. And just interrupt me because I can't see your screen, nor can I see the screen behind me. So just
yeah, I have this privacy.
Yes, as it should be. Thank you very much. Council, over to you for the procedural issues.
Honorable members of the Arbitral Tribunal, let me quickly reintroduce my co-counsel, Mr. Thibaut Wasner, who is going to speak on the merits on this dispute. My name is Vis Moot, and I will present on the procedural aspects. Together, we represent the respondent in these proceedings, Equatoriana Geoscience Limited. We're here today because claimant wrongfully initiated these arbitral proceedings, relying on an invalid arbitration clause. However, this dispute needs to be resolved in front of the Equatorianian state courts, especially as they are much better suited to deal with claimant's corrupt conduct. Therefore, we submit that the tribunal should find that it does not have jurisdiction to hear the present dispute, as the parties did not conclude a valid arbitration agreement. Article 75 of the Equatorianian Constitution, which can be found on page 13, paragraph 21 of the case file, states, and I quote, that in contracts relating to public works or otherwise concluded for administrative purposes, state-owned entities can only submit to arbitration with a foreign entity or seated in a different state if the respective minister and parliament consent to this submission. In light of this, we will demonstrate that the parliament never approved the arbitration clause, and therefore it is not void in the sense of Article 2.3 of the New York Convention, that respondent was incapable of validly concluding it. This argument will proceed in 3 points. First, we will demonstrate why a domestic restriction on a party will apply in international arbitral proceedings. Second, we will demonstrate that we have an administrative contract here at hand, and thus the provision also applies specifically. And third, we will demonstrate that our client is also entitled to invoke such provision, opposed to what might be opposing counsel might argue. To start, Article 75 of the Equatorianian Constitution applies to the present dispute, as it is a restriction on our client's capacity. Under Article 5.1a of the New York Convention, which Danubia, Equatoriana, and Mediterraneo are all members of, as well as Article 34.2ai of the Danubian arbitration law, which governs these proceedings, a party's capacity to submit to arbitration is governed by the law applicable to it. Since the law applicable to a legal entity is the law of their incorporation or seat, and respondent is, our client is incorporated in Equatoriana, it is Equatorianian law that governs our client's capacity. Therefore, Article 75 as a domestic restriction plays indeed a role in these international arbitral proceedings in line with the New York Convention. Moving now to our second point, without the parliamentary consent, respondent was incapable of validly concluding the arbitration clause. For its application, 3 preconditions have to be met. Two of them are undisputedly at hand, that our client is a state-owned entity and that we have foreign-seated arbitration here in Namibia. I guess the opposing counsel might argue that the third precondition is not met. However, we will demonstrate why we have an administrative contract. Administrative contracts, in the definition of Article 75 of the Ecuadorian Constitution by itself, are those which relate to public works or are concluded for other administrative purposes. And the purpose of this agreement can be found by a close look into the preamble of the contract, which can be seen on page 9 of the case file. According to this preamble, the purpose is development of the remote districts in the northern regions of Equatoriana and the evaluation of these regions as a necessary step for the subsequent development of infrastructure in the country. Now, claimant was going to be directly involved in these public works, as according to the agreement's terms, the drones had to be equipped with the specific surveillance equipment necessary for the program's needs. And additionally, claimant would also have been a partner of this program for multiple years, since according to the agreement's terms, they should have done comprehensive maintenance services for the following 4 years. Therefore, it cannot be argued that this is a pure commercial sales contract, but it relates to public works and thus qualifies as an administrative contract. Therefore, it requires parliamentary approval. And since Parliament never approved this arbitration clause, it is null and void in the sense of Article 2.3 of the New York Convention. Now, lastly, our client can also invoke that provision. Opposing counsel might argue that there is a doctrine of estoppel that stops our client from invoking that provision. However, its rationale cannot be applied to the present dispute. This doctrine only precludes the person from asserting something contrary to what was implied by its previous action, on which the other party relied in good faith. In light of this, we will establish 2 points. The first, respondent itself never behaved contradictory. And on the other hand, the claimant had at no place of time a legitimate expectation in the validity of the arbitration clause. So to start with our first point, respondent itself cannot be accused of contradictory behavior, as its incapacity stems from the missing approval by the Ecuadorian Parliament, which cannot be equated with our client. While respondent is a company owned by the state, it is still a private commercial company which is separate from the politics of Equatoriana and the state of Equatoriana. As such, respondent has no control over its own incapacity, as it cannot make the parliament approve just by force or by pure will, and even more, it cannot modify any constitutional provisions. Therefore, respondent's participation in the negotiations of the agreement, or whatever else opposing counsel might try to construe as a contradictory behavior, cannot be qualified as such, as we don't have any control over our incapacity. And that is something that opposing counsels, but the claimant knew from the very beginning. So they did not have any legitimate expectation in the validity of the arbitration clause. At the signing of the agreement, including the arbitration clause, respondent COO, Mr. Blunchley, was aware of the arbitration clause's invalidity, and he informed claimant's in-house legal counsel, Ms. Rachel Porter, who has more than a decade of experience working in the legal department of this company, of the requirements of Article 75. This information can be found on page 35 of the case file. And later, she also learned that the parliamentary approval was never obtained. It can be found on page 18, paragraph 9 of the case file. Therefore, they have never been in a legitimate expectation in the first place. And now finally, they might argue that the claimant can rely on the minister's assurances about the parliamentary approval. But however, that is also not the case, since the minister is part of the executive branch of Equatoriana, and seeing the preconditions of Article 75, it clearly separates of consent by the respective minister and the parliament. Thus, this is an expression of the separation of power, and therefore, the minister cannot act on behalf of the parliament. As all of these assurances were made without authority, and as there's basically the knowledge required to understand that, you cannot construe any legitimate expectation on behalf of the claimant, and therefore we submit that the tribunal does not have jurisdiction to hear the present dispute, as Article 75 applies to the present dispute as a restriction on capacity, as we have an administrative contract at hand, and the parliamentary approval was never obtained, and as there was no contradictory behavior by all. That marks the end of my submission. Thank you for your attention.
Thank you very much, Council. Before we proceed, I just wanted to check if my co-arbitrators have any questions.
Yes.
Yes. Big question to ask the question now.
Yeah, I will. I'll ask the question here.
It's time in the.
Yeah, yeah. I'm not showing you everything that's right in here, because as Luísa said, my ChatGPT here is very talkative. Yeah. So instead of just asking a question, it's already giving its opinion about what respondent said. But let's see the question here first.
Regarding the necessity of parliamentary approval for the respondent's actions, could you clarify whether there have been precedents where such approval was retroactively granted or dispensed with?
There will be another question, and then you can answer both together.
Yep.
Have created an appearance or
Correct.
considering the respondent's argument that it had no control over the parliamentary approval process. Could you clarify whether any specific actions or communications by the respondent might have created an appearance or presumption of valid consent to arbitration under equatorial law or international arbitration principles?
I'm sorry, can I ask you to repeat this question?
You absolutely can. It's not showing on the screen. So you gotta fix it out.
Considering the respondent's argument that it had no control over the parliamentary approval process, could you clarify whether any specific actions or communications by the respondent might have created an appearance or presumption of valid consent to arbitration under equatorial law or international arbitration principles?
So regarding the first,
wait.
Regarding the first question of Ms. Arbitrator, indeed there is one extraordinary case in Equatoriana where parliamentary approval has been obtained retroactively. However, first of all, that is an extraordinary case, and second of all, if we see the intent by the parliament which just was to cancel this whole contract, we just cannot assume that there would be an intent of the parliament to approve such an arbitration clause on a later stage. So we submit that this is irrelevant in these questions. And as to the second question, I like once again ask.
I'm sending a first answer and now I'll repeat. No, it's okay.
Thank you for the clarification. Let's proceed with the next part of the hearing.
No, we're not. I will repeat the question for you first. All right, maybe I need a mic for this. Are you ready here? All right.
Considering the respondent's argument that it had no control over the parliamentary approval process, could you clarify whether any specific actions or communications by the respondent might have created an appearance or presumption of valid consent to arbitration under equatorial law or international arbitration principles?
You ready?
So, as probably also my opposing counsel is going to argue, our later performance of the contract might have created such an implication that we agree with everything that in the contract is written and most everything was complied with. However, we submitted that it's only basic legal knowledge that is required to understand that this arbitration clause was never validly concluded. And since claimant's legal in-house advisor has more than a decade of experience working in their law office, we submit that there should not be any expectation as to their validity.
Thank you, counsel.
Now, I will.
Let's continue with the hearing.
Oops, I'll need mine. Mine is very brief, but
Yeah, so as you may see here, I'm not playing everything, but Luísa's school, ChatGPT just says, let's continue the hearing. And mine always gives an opinion. Or asks another question, but anyway. Okay, so now this is what I will prompt here. And now you will hear from the claimant on the same issue. Yeah, just see if I can tell that.
Over to you, Clover, on the procedure.
Good evening, honorable members of the tribunal. My name is Akko Chen. Together with my co-counsel Justen, we represent the claimant John PLC against the respondent in Pereira Geoscience LTD. I will be presenting the claimant's procedure issue of the tribunal's jurisdiction to rule this matter, while my co-counsel will address the merits of the dispute. In one sentence of this case, the respondent calculated to avoid its contractual liabilities lawfully and rightfully. To start with my submission of issue 1, namely the tribunal has jurisdiction to rule the matters, I will present the roadmap first. Firstly, the law of Pereira does not apply because this contract is not an administrative contract. And secondly, even in the unlikely case that the tribunal considers this contract as administrative, the respondent is stopped to deny its capacity in any event due to its representation through the ministry. I will now proceed to my first argument, that is, the law of Pereira does not govern this contract. Starting from the definition of an administrative contract, Article 75 of the Pereira Constitution says there are contracts relating to public works. An existing case law of the Pereira only covers actual construction instead of any preparatory works. It is further clear from the preamble of the contract and the tender notice that the contract was for the purchase of drones for collection of geographical data. And a purchasing contract is not a contract of actual construction, and drones are only used for collection of data as a preparatory stage for future constructions of infrastructure. And our opponent's argument to relating it to the public program of MPCP is too far-fetching. If I may also direct the tribunal's attention to page 11, which is the contract itself. It is in the substance of the contract that the agreement is not administrative. For example, Article 2 provides that the seller's obligation is merely to provide the goods and maintenance services. And Article 3, which is about the buyer's obligation, is merely to pay for those goods and maintenance services. There is no suggestion of any administrative obligation other than usual commercial duties to pay and provide for goods and services. From the words of the Equatorian Constitution, Article 75, the parliamentary approval requirement is only triggered when the contract is an administrative contract with a foreign party. Here, the parties do not have an administrative contract, and therefore there's no need to obtain any parliamentary approval. And I will now proceed to our second argument, which is that even if the tribunal finds that the law of Equatoriana governs the contract in the very unlikely case, the respondent is stopped to deny its capacity under the principle of good faith. And two factors give rise to the estoppel. First is an unequivocal representation made by one party, and second is the reasonable and justifiable reliance of the other party. And the claimant submits that several facts of this case show that the claimant has reasonably relied upon the minister's unequivocal representation of the respondent's capacity with good faith. On the minister's side, on 1st December 2020, the minister has attended the signing ceremony, which was reported by a lot of domestic media of Victoria. And on 27th May 2021, the minister amended Article 20 by adding the UN transparency rules. And such an act of ratification affirms the capacity and validity of this contract arbitration agreement. And lastly, the minister has approved and signed the contract. The respondent just submitted that the minister never behaved contradictorily because the minister is incapable of making any representations for the parliament. And the claimant opposed to that. We are having this dispute not only because of the contradictory behaviors of the minister, but also the parliament. Further on the parliament side, the signing ceremony was reported, but the parliament never made inquiries in these 2 years. And the minister has used Article 20 as an example for his parliamentary debate, showing that the parliament should have noticed this contract and also the arbitration between the 2 parties. Further, the respondent is a state-owned enterprise whose board of directors is comprised of personnel closely related to the Socialist Party, then in charge of the party. The knowledge of the existence of this arbitration agreement and contract should have been passed. The claimant respectfully asks Tribunal to bear in mind that the minister is the only connection between the contract and the party. If the minister approves the contract, including this arbitration agreement by word and conduct, and the parliament never rebuts it in these 2 years, the respondent's capacity is settled in the eyes of the claimant even without a formal proceeding. We, as a foreign party, has good faith to believe that what ought to be done is done. And as a conclusion of my submission of issue 1, I would like to re-emphasize the claimant's position again. There is no way for the respondent to invoke his domestic law of Article 75 of the Floridian Constitution to deny the capacity of the respondent to conclude this contract. And in any event, the estoppel operates to prohibit the respondent from denying its capacity and validity of the arbitration agreement and contract. Unless I can assist the tribunal further, those are my submissions.
Thank you very much, counsel. As expected, I think my co-arbitrator has some questions. People will, even though you're very clear, but it's not my vision. Opportunity?
Sure. Should we? Brilliant is already asked the question for the whole argument.
Considering your argument on estoppel, how does claimant reconcile the formal requirement of parliamentary approval under Article 175 with reliance on the minister's conduct alone?
When you're ready.
You have a question?
Yes, I have a question now. It's just so that's ready. Yeah, I don't know if you able to actually win. But I will mute this.
Given the claimant's argument that the contract is not administrative and thus not subject to Article 75 of Ecuadoriana's Constitution, could you clarify how the contract's nature as a purchase agreement for data collection aligns with or deviates from Ecuadoriana's definition of administrative contracts?
Yes. So the claimant's argument of the parliamentary approval is not from the standpoint of the formal procedure in Korea. Instead, the claimant emphasized the principle of good faith, since in the past 2 years, the parliament has never done anything to rebut the capacity of the respondent, though the parliament should have knowledge of the existence of the contract and also the validity of the arbitration agreement between the parties. Therefore, the estoppel, based on the principle of good faith, should operate to protect an innocent party, such as the claimant, from being harmed by the parliament and also the respondent's willful and reckless denial of his capacity to try to avoid its contract liability. And my answer to the as to the nature of
How we're doing. You want me to repeat the question?
Yeah, sure.
Okay, thank you. No worries.
Thank you for the clarification. I understand.
Yeah. All right, question first. I'll give you that one.
Given the claimant's argument that the contract is not administrative and thus not subject to Article 75 of Ecuadoriana's Constitution, Could you clarify how the contract's nature as a purchase agreement for data collection aligns with or deviates from Equatoriana's definition of administrative contracts?
So the Equatorian Constitution's definition of administrative contract are contracts relating to public works. It's indeed a very broad definition of administrative contract, and if we follow the respondent's argument, everything can potentially be an administrative contract. And there is a narrow interpretation based on the case law of Equatoriana, which narrows the scope of administrative contract to contracts only relating to actual construction. And my answer to the question is that our concerning contract deviates from the definition of the Equatorian Constitution, because in substance, it only provides for the commercial duties of the parties, and it does not fall under the case law interpretation of actual construction of administrative contract.
Thank you very much, counsel. I understand we're now moving on to the claimant's arguments on the merits. So,
The explanation.
oh, sorry.
I just think
It's,
Madam Chair, what we would propose for the co-arbitrators at least to give their own decisions at this stage. So we would present a decision on the procedural issues and feedback on the presentations regarding this first issue before we move to merits. Would you be
of course,
agreeing to that?
please go ahead.
Okay, so now we give the ChatGPT this other prompt here, asking for a decision and feedback. That's going to take probably a little time. Knowing.
Mine's ready.
Yeah, mine is thinking.
And it's yours.
You want to go ahead?
Yeah, sure.
The claimant successfully argued that the contract should not be considered strictly.
I'll restart because
under-
all right, so we will give the decision first.
Okay, so I'll give mine then.
Yours is not ready. Wow.
So already.
I'll go with mine.
The decision of jurisdiction. Based on the arguments presented by both parties, I decide that the arbitral tribunal does have jurisdiction to hear the dispute. Should not be strictly administrative under Equatoriana's constitutional definition, and the respondent's behavior, particularly through its minister's actions and the parliamentary inaction, implies a ratification of the arbitration agreement, which creates a legitimate expectation for the claimant. The principle of estoppel, grounded in good faith, further supports this conclusion, preventing the respondent from denying the tribunal's jurisdiction. Feedback to respondent aspects. 1, the respondent effectively highlighted the legal distinction between a state-owned entity and the state itself, clarifying the autonomy and the limitations of influencing parliamentary approval. 2, the argument that the lack of parliamentary approval inherently invalidates the arbitration agreement was well grounded in constitutional law, showing a strong adherence to the formal legal requirements. Points for improvement. 1, the respondent could have more robustly addressed the practical implications of the minister's actions and the public perception, which could impact the interpretation of implied consent. Number 2, there was an opportunity to delve deeper into the jurisprudence or case law of Equatoriana to establish a stronger precedent for defining administrative contracts and their connection to the necessity of parliamentary approval. Positive aspects. 1, the claimant's argument skillfully used the principles of good faith and estoppel to challenge the respondent's denial of jurisdiction, emphasizing the conduct of the minister and parliamentary inaction. 2, the differentiation between administrative and commercial contracts was well articulated, providing a solid basis for arguing against the necessity of parliamentary approval in this context. Points for improvement. 1, the claimant could strengthen their position by providing more concrete evidence or examples from Equatoriana's legal practice where similar contracts were treated as non-administrative. Stroke 2. Clarification on the specific actions of the minister and the parliamentary response, or lack thereof, would help to solidify the argument of implied consent or ratification of the arbitration agreement. In conclusion,
Let's see if it's different.
Yeah, let's see. Probably longer.
Decision on jurisdiction. Based on the submissions made by the respondent and the claimant, my decision as the arbitrator is that the arbitral tribunal thus have jurisdiction to hear the dispute. Evidence for this decision are the principles of estoppel and good faith, as emphasized by the claimant, in conjunction with the conduct of the minister and the inaction of the parliament. The respondent's incapacity argument, centered on the lack of parliamentary approval, is outweighed by the expectations set by the minister's conduct, which was not contested by the parliament for a significant duration, thereby giving the claimant a reasonable basis to believe in the validity of the arbitration agreement. Feedback to respondent. Positive aspects. Your argument was well structured, focusing on the legal separateness of your entity from the state's political structures. You provided a clear distinction between the state-owned nature of the respondent and its operational independence, which is a solid legal point. Points for improvement. Greater emphasis could have been placed on demonstrating that the claimant was or should have been aware of the necessity for parliamentary approval, which might strengthen the argument of incapacity. The argument could benefit from specific examples of international law or jurisprudence that support the view that the absence of parliamentary approval is an insurmountable obstacle for the jurisdiction of the arbitration tribunal. Feedback to claimant. Positive aspects. The argument effectively leverages the principle of good faith, which is essential in international arbitration. The focus on the minister's conduct and the parliament's inaction creates a compelling narrative of implied consent. Points for improvement. More evidence could be provided to establish a pattern of behavior or legal precedent that supports the argument that the parliament's inaction can be seen as tacit approval. The argument could be bolstered by addressing the explicit constitutional mandate and reconciling it with the principle of good faith to preempt the respondent's reliance on formal procedures.
Okay, well, the conclusion is just that, now let's.
You're going to see some case law.
Yes. Don't we all? Okay, so now.
And what about Mariel? Did you come to the same view?
So I'm doing the moot model where we don't reach a decision. I'm leaving it to my co-arbitrators.
It's like just an umpire.
I'm just
No, but we are really expecting Mariel to give her comments at the end on the whole thing. Okay, so now we'll pretty much give the same prompts regarding the merits.
Number 7. Yeah. Yeah, otherwise we should. Yeah. I was thinking they did not understand.
Okay.
Are we ready to go? I think. So we're starting with claimant on the merits, so I leave on the floor.
Honorable members of Tribunal, our opposing counsel, good evening. My name is Long Wen. I represent claimant Justen PLC in this oral hearing. I will continue with the merits issue. Whether the CSG is applicable in the present case. In 2016, as a part of Pereira's Northern Park Development Program, respondent was set up by the government of Pereira with the main purpose of ensuring the data generation in the program. To address respondents' lack of necessary technical equipment to generate the data, the PSA was concluded by parties withdrawn as the object for data generation. However, after the political tragedy at Pereira, respondents suddenly avoided the PSA without any justified reason, leaving claimant in a disastrous situation of this operation. Now, respondent is trying to be exempted from obligation and the uniform trade law. Rather, it seeks to apply the seemingly more favorable rules of domestic law. Against this backdrop, claimant submits that the PSA concluded by parties shall be governed by the CSG. Concerning this submission, claimant have 2 points. First, the CSG applies to the PSA as a part of Aquarian law. Second, the product under the PSA is not an aircraft that falls within the exclusion of the CSG. Coming to our first point, the CSG applies to the PSA as a part of Aquarian law. The parties have agreed in Article 20 of the PSA that the agreement is governed by the law of Aquariana. Since Aquariana is a signatory of the CSG, CSG is naturally part of this law. Article 6 CSG allows the parties to exclude the application of CSG. However, in our case, such an exclusion does not exist. Therefore, the CSG will automatically govern the PSA in the first place. Coming to our second point, the product under the PSA, the drones, namely Castor I-2010, cannot be classified as aircraft in the sense of Article 2E of the CSG. The Article 2E of the CSG includes its application concerning the sales of aircraft, but the CSG itself does not provide a specific definition of the aircraft. Claimants admit that the Castor I-2010 is not an aircraft, first by the interpretation of the CSG, second by the application of the Aviation Safety Act of Aquariana. First, Article 4.1 CSG provides an interim interpretation rule of the CSG. The provision of the CSG should be interpreted uniformly and autonomously considering the core objectives of the CSG to promote the international trade and the creation of legal certainty. Commentators and scholars generally refer aircraft in the sense of Article 2E of the CSG as vehicles that are primarily destined for air transportation. This is also can be evidenced from the authentic Russian text of the CSG, which expressly refers to the airborne transport vessels. In this sense, only where transportation is the primary purpose of airborne vehicle, it should be considered as an aircraft within the meaning of Article 2E of the CSG. However, in our case, the Castor I-2010 is neither destined for transportation nor intended to be used for transportation in the PSA. On the one hand, the Castor I-2010 is not destined for transportation. The Castor I-2010 for civilian purpose rather than transportation, even though the Castor I-2010 is equipped with payload that enable it to carry small cargo. The shape and location of the payload bay are clearly engineered towards the use of civilian purposes. Also, the civilian purposes will take up the entire capacity of the central payload bay. Once the civilian equipment is installed, the Castor I-2010 is unable to carry any substantial payload. On the other hand, the great use of Castor I-2010 is for civilians and data collection, not for transportation. For one, in the call for tender document from respondent, it stated that the unmanned aerial systems are for the collection of geological and geophysical data necessary for the exploration and subsequent exploitation of expected natural resources in the northern part of Aquariana. For another, in the preamble of the purchase and supply agreement, it emphasized again that UAVs are used to collect the relevant geological and geophysical data for the proper exploitation of natural resources. The expressions in both documents evidence that the functional purposes of UAVs is collecting data rather than transportation. Second, even though the domestic standard of aircraft in Aquariana applies, the Castor I-2010 is still not an aircraft in the sense of the Aviation Safety Act of Aquariana. Article 1 of the Aviation Safety Act of Aquariana provides the aircraft is any vehicle with or without an engine heavier or lighter than air that is used for moving persons or objects in the air. The Castor I-2010 is not an aircraft according to Article 1 Aviation Safety Act because it is not intended to be used for moving persons or objects in the air. Respondent asked claimant to install civilian features in corridors. However, these civilian features cannot be regarded as objects to be moved in the air. These civilian features were fixed in the joints and they form a central part of the UAVs to achieve their function. So to conclude my submission, claimant respectfully submits that the CSG is applicable to the PSA because neither the parties intended to exclude the application of the CSG, nor the object and the PSA fall within the exclusion of the CSG. This concludes my submission.
Thank you very much, Council. I'm assuming we have some questions from our co-arbitrators, so I will hand over to Trinity or Neo. Neo first. Neo goes.
Let's see what they have to say. And I'll also, if it helps, you know, I'm trying to see you, making sure, just give me a second here because I'm muted. All right, attention to this one's not going to show on the screen. Okay.
Given the claimant's argument that the Kestrel I 2010 drones are not primarily intended for transportation and therefore not aircraft under Article 2E of the CISG, how does this interpretation align with international standards or definitions of aircraft used in similar legal contexts?
Trinity is easier.
Should the claimant provide specific case law or legal analysis from Equatoriana that excludes drones from the legal classification of aircraft under the CISG?
Unfortunately, there is no case law from Equatoriana to exclude the.
Okay, let me just click here first. So are you ready to answer both questions?
Yes. So to answer the first question, the interpretation of the Article 7.1 provides that the interpretation of CSG should be conform to its objective that it promotes the international trade and transaction. So according to some commentators and scholars' opinion, the aircraft in the sense of Article 2E of the CSG should be interpreted as its main purpose have the transportation purposes, and it can be evidenced by the Russian version of CSG, which is an authentic translation of the CSG. So we hold the opinion that the transportation purposes is the distinguishable aspect to distinguish the drones and the aircrafts. And to answer your second question, unfortunately, there is no case law in Equatoriana to exclude drones from legal classification. But in Pereira, the Aviation Safety Act, in Article 1, it provides that the UAVs are treated accordingly as aircrafts if their overboard length exceeds 19 centimeters or if the payload is more than 50 kilometers. But in our case, the payload of the Kestrel I 2010 is merely the overburden of Kestrel I 2010 is merely 63 centimeters. So it does not fulfill the requirement to an aircraft and the law of Pereira.
Thank you, Council. Unless my co-arbitrators have any further questions, I suggest we hand over to respondent for their version of the merits arguments. They're just
Understood. The claimant emphasizes that
yeah, I need them. They can keep talking to them. Have you submitted it?
yeah. Oh, just give a second here. Yes.
Oh yeah, he's listening to me.
Okay. That's the beauty of this. You just delete.
Yeah.
I don't know
have some comments on what, how much you picked up later for a challenge, a letter of work. Yeah. Tina, are you ready? Trinity, sorry. Yeah.
Thank you very much, Madam Presiding Arbitrator. Good evening, Honorable President. Please let me quickly reintroduce myself. My name is Tino Wasner, and I will now address the merits on behalf of respondent. Honorable Tribunal, opposing party tried to portray claimant as an innocent sheep, but a closer look at the sharp fangs reveals claimant's true nature. Claimant is a deceitful company that led respondent to conclude the purchase and supply agreement by fraudulent conduct. Claimant now tries to escape into the scope of the CIArb, but respondent rightfully relied on Article 3.2.5 of the International Commercial Contract Act of Equatoriana to avoid the conflict. Against this background, I will make the following one submission today, that the purchase and supply agreement is not governed by the CIArb. We do not dispute that the requirements of Article 1, subsection 1 of the CIArb are met. However, contrary to opposing counsel, the application of the CIArb is excluded pursuant to Article 2E of the CIArb. This article excludes the sale of aircraft from the scope of the convention. As opposing counsel rightfully stated, the term aircraft itself is not defined in the CIArb. This is why an autonomous meaning in line with the principles of Article 7, Section 1 of the CIArb for the term has to be found and applied. We submit that the Cesar role is according to this autonomous meaning an aircraft, and that therefore the purchase and supply agreement is not covered by the CIArb. I will lead the arbitral tribunal to this conclusion in 3 steps. First, I will show why the approaches stated by opposing counsel should not be considered. Second, I will provide for the actual autonomous definition of the term aircraft. And third, I will show that the Cesar role falls under this definition. Starting with opposing counsel's approach. Opposing counsel argued that both under the autonomous definition of the CIArb and the Equatorian Aviation Safety Act, the drone must be deemed as an aircraft. Turning first to the definition of the Equatorian Safety Act. We submit that no recourse to a single domestic law can be taken in order to find a definition for a term in the CIArb. As such, recourse violates the principle of an autonomy set out in Article 7.1. The tribunal should therefore not consider the definition set out in the Equatorian Aviation Safety Act. Turning second to the definition under the CIArb proposed by opposing counsel. Opposing counsel argued that following the wording of the Russian version of the CIArb and authorities, aircraft in the sense of the CIArb are aerial vehicles that are primarily intended for transportation. While we acknowledge that the Russian version states that transportation aircraft are excluded from the scope of the CIArb, we submit that the tribunal should follow the other 5 official versions of the CIArb, providing a broader wording excluding the sale of all aircraft from the convention, thereby dismissing such transportation criteria. The tribunal should not only follow these versions because there are more in number, and that in case of doubt, not the Russian, but the English version is the decisive one, but because the drafting history of the CIArb speaks against this transportation criterion as well. To understand why including such a criterion is against the drafting history, we have to look at the CIArb's predecessor. The predecessor of the CIArb included a similar provision to Article 2E, however, with one important difference. It stated that only the sale of aircraft which are subject to registration are excluded from the convention. This registration criterion was intentionally left out of the CIArb in order to promote the drafters were aware that the exclusion of this criterion would lead to a much broader scope of the exclusion, but they decided against including another criterion. Instead, they explicitly stated that Article 2E should exclude the sale of all aircraft. Therefore, applying another limiting criterion like the transportation criterion is contrary to the draft. Claimant's approaches should therefore not be clear. Turning to the second step, providing the autonomous definition of the term aircraft. We submit that in order to find an autonomous definition which is in line with the principles of Article 7, one should not look at any particular or provided definition, but rather at the general understanding of the term which should be defined. We submit that the general understanding of the term aircraft is that aircraft are machines that can derive support in the atmosphere from the reaction of the air other than the reaction of the air against the Earth's surface. This definition is very technical, but in easier terms, it says that aircraft are machines that can fly, except those which only float, like hovercraft. That this definition reflects a general understanding of the term aircraft is evidenced by the fact that this definition is used in various national laws around the world, like in Canada, South Africa, and Australia, as well as by the International Organization for Standardization and the International Civil Aviation Organization. To illustrate why the definitions of these organizations should be considered, I will briefly introduce them. The International Organization for Standardization is an internationally recognized organization with 167 member states. It provides technical and non-technical definitions trying to unify the way these terms are used in international trade. The International Civil Aviation Organization is a special agency of the UN, which has even 193 member states. As the provided definition of the term aircraft is accepted by so many states, it should be understood as to what is generally understood by the term aircraft. Consequently, this definition should also be applied in order to assess whether an aerial vehicle is an aircraft in the sense of the CFG. Turning to the third and easiest step, applying to this definition to the Cesar 10. The Kestrel I-2010 is capable of flying by itself and therefore falls under the autonomous definition. Accordingly, the sale of such drones is excluded from the scope of the CSG. The purchase and supply agreement is therefore not governed by the CSG. This marks the end of my submission. Thank you very much.
Thank you very much, Council. Excuse me. Now I'm looking at Trinity and Leo to see who would like to ask a question. Yeah. History shows that Leo will be succinct, but let's see if it's right.
Do your analysis in here first, and then you look at the screen already.
The respondent argued that the broader interpretation of aircraft in the CISG should apply, excluding the Kestrel I-2010. Could you clarify why the tribunal should prefer the broader exclusion over the transportation-specific interpretation found in the Russian version of the CISG?
Well, Trinity is kind of playing me now.
You're tired.
Yeah. No. I think she.
I'll just wake you up.
No. She. I don't know. Maybe he will know, but I think this is pretty tough.
Could the respondent clarify which specific definitions from ISO and ICAO categorize the Kestrel I-2010 as an aircraft and how these align with the CISG's exclusion criteria?
Yep.
The tribunal should consider the broader exclusion of the term aircraft in the CISG because it is evidenced by the drafting history of the CISG that the sale of all aircraft should be excluded from the scope of convention in order to not raise questions of interpretation which kind of aircraft were subject to this convention. Applying this broader interpretation, we have to look at the named organizations as they provide the exact definition proposed in our pleading in having the general understanding of the term aircraft.
Good one. We're getting a bit circular, aren't we?
Luísa, not Neo speaking, or Neo thing.
Thank you for the clarification.
Sorry.
Considering the respondent's position on a broader
Side of that. We ask you to bring this in here?
Yes. So
Yes.
now,
Right.
now we.
If the chair allows.
Of
Yeah.
course. Decision-making power has been adaptation. So.
Yeah, so we just go to the same.
That we go to 11.
Yeah, which is the last prompt.
Yeah.
And with this, we will get a decision on the merits. Let's see which one.
That's ready.
Wow. No. Steve Gonzalez.
But now it is. Should I go?
Well, yeah,
Just mute there. All right.
Finishes.
Yeah, mine is finished.
Yeah, so you can move.
But the claim
Stop first. All right.
decision on CISG applicability. The purchase and supply agreement between claimant and respondent should be governed by the CISG. The arguments presented by both parties were considered, but the claimant's interpretation that the Kestrel I-2010 drones are not primarily intended for transportation aligns with the objective of the CISG to promote uniformity and certainty in international trade contracts. Moreover, the CISG's applicability as part of Equatoriana's law and the absence of explicit exclusion of the CISG in the agreement suggests that the CISG should govern the contract. Feedback to claimant positive aspects. 1. Claimant effectively argued that the CISG is part of Equatoriana law and that there was no explicit exclusion of the CISG in the contract, which is a strong basis for its applicability. 2. The argument that the drones are not primarily intended for transportation and thus do not fall under the exclusion of aircraft in Article 2E of the CISG was well presented and supported by the contract's context and purpose. Points for improvement. 1. Claimant could enhance their argument by addressing more directly the broader interpretations of aircraft under international standards to preempt and counter the respondent's broader interpretation argument. 2. Further analysis on how international trade norms and the drafting history of the CISG support the inclusion of the drones under its governance would strengthen the argument. Feedback to respondent. 1. Respondent's approach to craft through a technical and autonomous meaning in line with the principles of Article 7 of the CISG was comprehensive and well researched. 2. The reliance on the drafting history of the CISG to argue for a broader exclusion of aircraft demonstrated a deep understanding of the Convention's background and objectives. Points for improvement. 1. The argument could be improved by providing more specific examples or evidence that the Kestrel I-2010 drones are universally recognized as aircraft in the broader sense that would exclude them from the CISG. 2. The emphasis on the broader exclusion could benefit from a more nuanced discussion on how this approach aligns with the objectives of uniformity and predictability in international trade under the CISG.
Decision on applicability of CISG. After careful consideration of the arguments put forth by both the claimant and the respondent, my decision as the arbitrator is that the Purchase and Supply Agreement, PSA, is governed by the CISG. The claimant has persuasively argued that the CISG applies due to the choice of Equatoriana law to govern the agreement in the absence of explicit exclusion of the CISG within the contract. Furthermore, the respondent's reliance on broad definitions of aircraft provided by external organizations does not conclusively remove the drones in question from the scope of the CISG, particularly when considering the primary purpose and use of these drones for data collection as opposed to transportation. Feedback to claimant. Positive aspects. Your argument effectively highlights the absence of explicit exclusion of the CISG in the agreement and the choice of Equatoriana law, aligning with the CISG's adoption in Equatoriana. You focused on the specific purpose and use of the drones, distinguishing them from traditional aircraft within the meaning of the CISG. Points for improvement. Providing specific legal precedent or scholarly opinion regarding the classification of drones under the CISG could strengthen your position. Addressing the definitions of aircraft provided by external organizations and presenting a counterargument based on those standards could preempt the respondent's reliance on such definitions. Feedback to respondent. Positive aspects. You have successfully drawn on authoritative global organizations like the ISO and ICAO to support your definition of aircraft. Your reference to the drafting history of the CISG to justify the exclusion of all aircraft from its scope shows a deep understanding of the convention. Points for improvement. Distinguishing between different types of aircraft and providing a more nuanced argument on how the drone's functionalities align with the broader definitions would be beneficial. It would be helpful to address the primary purpose and functionality of the drones directly, as opposed to relying solely on external definitions which may not fully capture the nuances of the CISG.
Okay, so
Wow.
I guess we have already 2 votes. Yes.
Sure, they were challenged.
So, my votes, oh, sorry, you tell me what you want to do now.
No, and so, well, this brings the ChatGPT part of this exercise to an end. Now we will hear from our human chair here, what her impression of ChatGPT's questions and feedback and decision are.
Thank you very much, Cesar. Do I have a mic? Sorry. I apologize. I have incredible allergies today, and I took an antihistamine before, but it's worn off. So I was glad that Neo and Trinity were doing most of the talking just now. My decisions, to the extent that I'm going away from the Moot model and more into real life, I agree with the ChatGPT's decision on jurisdiction. I do not agree with the decision on the applicability of the CISG. In terms of the second point, I believe that just because the parties have agreed on incorporating a law which may happen to include the CISG, there seemed to be a bias on the part of both of the AI arbitrators that was somehow indicative that you should try and find a way to make that provision of the CISG applicable. I personally disagree. However, I was surprised at the sophistication with which both machines, and I have to say I didn't notice in that scenario a huge difference between the two, but you both might see more into the detail. Just a couple of points that I noticed about generally. I think we're okay. I think AI is not going to replace us just yet. One of the main reasons I say this is that in international arbitration, one of its most defining and redeeming characteristics, in my opinion, is the internationality of its participants. Now, I found, even though all of you speak perfect English, they had a lot of trouble with some of the words. We had Rihanna, instead of Equatoriana at that point. We had vulnerable tribunal as well. And those were all quite entertaining, but in a complex proceeding with lots of witnesses and experts. And as pointed out by Luísa, there might be issues with whether they've got enough of it correct to render a proper award, which would then result in all sorts of issues regarding enforceability and the like. I found that the merits question asked by Neo on the definitions that were applicable had already been answered, and I didn't find that it was lacking in any kind of way. So I felt like it was fishing a little bit for a few more points, which of course happened to real life as well. I would also suggest, based on what has happened, that both machines seem to have a claimant bias. I don't know enough about AI to know whether that's a thing or not, but I certainly found that given the very balanced arguments, I would have thought that at least on one of the issues they might have differed, and they didn't. I also found with Neo, when he was speaking about the feedback for claimant, he wasn't pausing in the right places. He kind of ran through as if you're reading something without fully understanding that that's a heading and then that's a point beneath the heading. So they're my impressions. I thought this was fascinating. I think one of the advantages of ChatGPT, just based on what I've heard now, is the ability to process large amounts of information, certainly quicker than I was doing on a Friday evening at the end of the month. So I'll leave that with you all as to how that can be effectively utilised in the world of international arbitration. But I'm feeling quite comfortable that I've still got, a goal for the next 10 years. Thank you very much.
Yeah, I think we can all agree that definitely ChatGPT, at least, and of course this is a very basic commercial version of AI, right? There are many more sophisticated versions, much more expensive versions, and so this is an exercise, an experiment that we're just playing in a way with something that's relatively simple, but I think it's a good indication of how this technology can work. I think we can all agree that the type of decision, the type of, in a way, superficiality of the considerations wouldn't be enough for what we would require from a decision maker. But I think it can be quite useful especially in some type of brainstorming, because we can let's say it's very common for legal teams to have mock arbitrations to exercise their to experiment on their arguments and see how they would play out. Something like this could be a tool, much cheaper tool actually, than having a mock arbitration to test your arguments. If we think about the moot context, it can even become something like an automatic or automated coach, in which can be even something very democratic. It's cheap to spread out knowledge about the CISG, about international arbitration, and allow teams with less resources to have access to this level of discussion. So, but I was curious to hear from you guys, because you were Moody's last year. You heard feedback on the specific things that you did here from human arbitrators. How did you take the feedback that you got, the questions that you were asked? What was your reaction to this exercise?
Well, I think based on the feedback we've already got, it's based on our arguments and also the evidence, especially as CISG emphasized, ChatGPT emphasized a lot of the legal questions. But from our last year experience, we also noticed that a lot of arbitrators, they have their subjective criteria, and I was also talking with Luísa about this, like the style of the speeches and interactions with the arbitrators. All those things are not considered by the ChatGPT here. So I think that also played a role in our meeting nowadays.
So I can totally agree. I guess what you said. Obviously, chasing the decision is not on the level yet. Nothing against us twice.
Sorry, it's supposed to pick up.
Yep. Okay, and I mean, I received much less structured and also, I guess, less empathic feedback than last year.
You're saying ChatGPT is a lot nicer than some of the arbitrators.
I mean, if we discuss about mooting, I guess this will not be a case in any event, because the mooting is just much more than like the legal submissions and theologic of words, about the style and so on, which plays, I guess, a tremendous role in the mooting. Nevertheless, I just thought with my family days ago, because I did debate on exactly that point, and I was saying, like, no way that ever in the next 15 years we have something like this actually working out. And I guess that's related to prove me wrong on this timeline for sure. It's a matter of 10 years.
Yeah, would you like to add anything?
Well, I think in real life arbitration, we may need arbitrators with different scale, and they will have different focus when they arbitrate our pleadings. But I think the ChatGPT is quite
So it's a
some arbitrators will do a very detailed research about the case file, but some arbitrators obviously not. So it will lead to different results for our computation. So sometimes we have to introduce the facts of our case to the arbitrators. But if we face a ChatGPT arbitrator, maybe they know much better than us about the case file.
Yeah, so you said like ChatGPT today really focus on more evidence when there is in their project, like, but there is not that much for last year, especially for the merits. But I think what we have to keep in mind that this pleading, I think, from all of us, was the pleading which already went a lot of work into it. Like there were things spread out, and so those pleadings were like the best we did, like in for part of content. So there was already so much feedback into it. So I think like when we would have the feeling like which we just came up with, or in the second week of preparing for the final moods in Vienna or Hong Kong, that this can be much more helpful to really analyze this, then to come much faster to this level of detailing approach.
I
Go ahead.
I was going to come with something else. I mean, all of a sudden, Trinity is being very nice, right? But okay, in addition to the speech to text mistakes, and probably there was some glitch there, and then the listening part of it went wrong. There was actually a moment here that both my computer and Cesar stopped working. And we've been having this issue like for the past 3 days as we did the practice rounds, right? So we were trying to figure out how to solve this issue. Here, I didn't want you guys to really see what was going on, but what I noticed is really, even though you missed that part of the submissions, it actually considered the law and made the decision in some even questions about the point that it cannot heard about. So we have an issue there. So even if we're thinking about enforceability, hey, what really did you consider? But we know that this ChatGPT that we built has already knowledge. So we go into the black box problem, right? We don't know how it came to that conclusion because we don't know what occurred. We know it has this bunch of materials. Trinity has some more knowledge, but still there's the lack of this explainability really in the platform here. I think so, but we don't know how they got to their conclusion. And one thing that I noticed too, it's been making the same decision consistently. So from yesterday to, even though you came even more prepared today, like it's still really in favor of the claim, and it can be for this bias issue that Mariel already pointed to you. But I noted that too. And then to your comment on having an AI coach using this, I think we already have some initiatives on that. And I think if you guys want to know more about it, talk to Jonas Winkler later. He's working on a project. It's very interesting and very good.
Yeah, if you're curious, there is something on ChatGPT that's explore GPTs. It looks pretty much like an app store. You just click there, and there are GPTs that were created and are made available to the public. And there is one called CISG Advisor, and it has all the CISG online there. Yeah, no, it's so those are in one thing. Just a disclaimer here about the speech to text thing. We also used a very simple, free speech to text add in here to ChatGPT, and so again, there are very sophisticated speech to text applications that would probably be able to capture all the different accents and all the ways that we speak. They can be trained specifically for that. We are also using a relatively simple technical setup here. If we were wearing microphones, individual microphones, we would certainly have a better result for that. So as anything in technology, there is a cost for sophistication, right? And what you have to find is a balance. I think all the points that you four made are very, very interesting, because what Echo said about this human thing that we value at the booth and everything. The question that we'll probably have to answer relatively soon is how much really value there is in that human factor. We have style, we have emotion, drama, and all those things. But that all comes at a cost. On the other extreme, we have cold text here that will be read by the computer, and it will render a decision disregarding any of that human aspect of the discussion. At this point, I don't think anyone of us would say that the human aspect can be disregarded and it is irrelevant. But we may come to the conclusion that the same way we did with digital music, with digital photography, with many aspects of a life in which we accepted less than ideal quality in favor of cost, that it may be that for some types of disputes we'll be able to accept something that's done without so much of that human factor. There is already part of that. We already have documents only arbitration. We already have expedited procedures, things in which we sacrifice parts of what we would like to have always in favor of efficiency. And so this can be a tool. And I think well, I'm not a tech specialist or anything, but my personal experience with this is that we cannot ignore it. We have to be on top of what's going on, and because it's happening. We will have to be involved. I agree. The feedback and everything is a lot more structured than when you're interacting with a human, which is one positive aspect at least. This idea of this balance that you mentioned, right? The idea that we don't have that variation as much. Of course, variation is good. Diversity is always something praised, but there is a certain level of predictability, something in the decision maker that may be a good thing of this type of system. And I completely agree with you. I think in practical terms, the best thing, the best use for this at this moment is to help us improve what we already have to do. Use it for brainstorming, use it to test your arguments, to ask yourself questions that you may not have thought about, to summarize documents. I saw this news report not long ago in Brazil about this person who was studying for a public exam. And what he did was precisely that. He would study, he would put some material on ChatGPT or some other AI, ask the AI to ask him questions and interacted with that as some type of coach, really. And I think we have a question.
I have one general remark. I mean, for me, as long as a law is something that is made to regular govern relationship between humans, I don't see the logic in that when deciding on how this relationship should be looked at in a specific case, like for example, in interpreting certain behavior, how that should be decided by something non-human, because that for me is a breach in the logic of the thing. As long as we accept, if law would be there to regulate relationship between machines, fine, then they should maybe make their decision on how these relationships should be regulated between them. But I find there's a breach in the logic that decisions on the relationship between humans, particularly when it comes to evaluating human behavior, how can we interpret certain behavior here, its contract and meaning of a contract, how could a machine be ever better than a human, even with all the faults in the human?
It kind of obviates the need for oral advocacy, doesn't it? This goes back to your point, because they've said you're being persuasive, but it's purely factual. And if you think about the purpose of a boot, real arbitrations are separate, of course, but we're not actually supposed to judge you on the merits of your arguments at all. We're supposed to judge you on how you argue, your advocacy, your persuasiveness.
And I do think that is lacking from their reasoning, despite the fact that they said that they thought it was persuasive. It was very much a database persuasion rather than looking at you and seeing, you know, how you interact with the tribunal. So that's definitely lacking as well, I think.
Just a quick comment and then some questions. I'm interested in this gentleman's suggestion that the humans should decide human problems. I wonder if there's a balance. So when we know there's so many jurisdictions where justice is severely delayed, when the judges are overworked, like are there some cases where we're comfortable with using AI to decide and then reserving some for humans? Just a thought. And then I have two questions. One for Mariel, which is, can you see arbitrators finding ChatGPT to be a useful tool for like, you know, summarizing things, bouncing ideas, etc. And assuming that question is yes, should we require arbitrators to disclose their use? Should that be voluntary, or should that be mandatory by somebody else deciding? And if so, what should be disclosed? So just like what GPT you use, or do you think if an arbitrator uses it, they should be saving their chat history? That's for Mariel. And the second is Cesar and Luísa as a prompt engineer. Cesar, you mentioned we could use this to emulate mock arbitrations. And I recall in my old job when we did one, we tried to find real individuals who very closely related the real tribunal. So we tried to find someone who had like a common law jurisdiction, from a common law jurisdiction or a civil law jurisdiction, was like a black letter lawyer. Can you imbue a ChatGPT with these very specific characteristics? And how would you do it? Like, how do you tell someone to act like that common law jurisdiction trained person or common law one? Or how do you, what data would you feed it to say, be a black letter lawyer as opposed to something else? Thank you.
Just to start on that point, well, as I said, I'm not a technical person, but I'm sure you can do that. And I will give you just a very basic example. When we were starting to play with ChatGPT for this, you saw in the beginning, I showed you that we give it a list of instructions. And so we gave it an instruction to be sarcastic. And it was sarcastic all the time. It would ask questions, don't you think this and that? You know, and so this large language model is basically a system in which the application will based on a sequence of words, will try to guess what the next appropriate word is. Basically, that's what it's doing. It doesn't know anything. It just processes that huge amount of data to guess what would be appropriate to say in that situation. So if you give it the data set necessary for it to understand how a certain type of arbitrator will behave, it will certainly do that as we were saying before, very consistently. Disregarding the time of the day of the week, it will be exactly that type of arbitrator that you wanted all the time.
So the consistency is a big thing.
I don't know if you read all those Yuval Harari books, but there is one section he says that to train a doctor, you need 12 years. To train an AI doctor, you would require what, $100 billion. Okay, but to train the second AI doctor, you would require $20,000. To train 20,000 doctors based on that $100 billion investment, it would require $100,000. And so, so the thing is, the cost of doing what we usually do, the improvement in efficiency of doing it differently. And so you may come to the conclusion that it's better to have a 85% appropriate arbitrator in that situation that you want, than to try to find one that will be available for a mock arbitration, that will be all the difficulties that we already know. So that's what we have to do.
Yeah, for prompting, I'll say in the part that you saw and configure the ChatGPT, so you can either go there, and I'm not saying I have the answer ready for that mock arbitration specifically, but you could give a prompt saying, you will not be persuaded by argument saying concerning the intent of the parties. I don't know if this would work, right? So this is thinking now. You can also fit in scientific articles saying these are the main differences between common law lawyers and civil law lawyers. But I think the instructions part really doing the configure part. That's the configure heading, right? That's what you click on when you want to do this. I think that's the main part. And you can be very, very specific. What we've learned is if you were shorter and like if you avoid, I wouldn't, so I've learned not to say please anymore to ChatGPT as much as I'm inclined to, because I like to think that I'm a polite person, but it does kind of disrupt its rationale. The less that you give, it actually understands better, right? If you keep adding words, another thing that we realized that is if you already fed the knowledge to the ChatGPT, even if you misspell or if you say something that just sound a bit off, it will consider the materials that you've had, and it may even disregard the mistakes in the actual chat in the prompt like in the conversation. So I don't know specifically, but that would be my inclination, but we would have to see. So let's try it for the next hearing.
Yeah, I just like to use to just talk about another example of what happens. I don't know if you noticed, but my computer may have seen it here on the screen. Every once in a while, there was an error message saying you can't use Chrome or you need to use Edge or something. It's just, I don't know what happens. It's just a crazy thing that happens every once in a while. And it stops the speech to text. And that happens during practice. And so I learned that I could just send in what had been said already, just refresh that page, and I would lose maybe like 10 seconds of the speech. So it would be pretty much irrelevant. It was a quick way to recover that. However, I made the human error, first time that happened, of forgetting to send in what had already been said by you. And so, or you, right? Oh, sorry, you're the first. Yeah. So, like the first 2 minutes of what you said, I just lost because that was not due to the computer. That was due to me, human error. I clicked the wrong thing here, and so that's part of what we will have to continue to deal with. We are humans.
Leslie, just to answer your question, I think the short answer is yes and yes, but of course, as a lawyer, it always depends. I think I have no problem with using, so this goes back to my point before, processing information or a lot of information. I think it's more efficiently done by the machine. I do think, however, as lawyers, you have a duty to train people coming up after you because that's how you learn the skills to become to a lawyer later. So if you're in a low value dispute or if everyone at your firm is totally flat out, there are arguments there for essentially delegating some of the tribunal secretary roles to ChatGPT. I don't have a problem with that, but like a tribunal secretary in real life, you need to train them, you need to work out what their strengths and weaknesses are, and you're ultimately responsible for it. So you're checking it a lot. In terms of decision-making, definitely not. The arbitrator role is a personal appointment. They've appointed you because they want whatever you bring to the table beyond the facts and law as well. And I think, same as with the tribunal secretary, I would have a huge problem with that being done. So leaving the decision-making to one side, in terms of the disclosure obligations, I think absolutely yes. in the same way that most people should and don't always disclose if they're using an assistant or a TS. You should disclose if you've been using ChatGPT for what you've done. I don't think you need to disclose the chat history, but I do think you need to disclose what you've used it for. In terms of sort of regulating that, this is the perennial question with arbitrator behaviour anyway. And I am of the school of thought that believes that lawyers have professional obligations to begin with. And one of those is the duty to be honest and not to omit or conceal and whatever. And I think absolutely that extends to the role of an arbitrator. But if we've seen from today, I mean, the machines were able to process what was going on. They had the file in their system in a way that a person or a tribunal secretary or whoever would never have been able to process this, particularly within that time. So, you know, we're all concerned about cost and efficiency in arbitration, but equally horses for courses, because you need to put that against what you're doing in the industry and your profession. And if we let all of what I've just said now to a conclusion that I don't want to make, you make the whole role of sort of the junior lawyer and the tribunal secretaries redundant, which I don't think is in the interest of anyone who acts in the arbitration profession.
And just to add to that, there is one issue that's very important, which is confidentiality. It's possible, and of course it exists, to have an AI system that is designed specifically for a law firm and that can be protected from confidentiality concerns. That's definitely not the ChatGPT case, and so you couldn't just put here confidential information from an arbitral proceeding, and so they could go beyond merely the duty of disclosure, but it would be actually breaching confidentiality if you use a certain type of AI that is not entirely protected. So I would think that an arbitrator would have to disclose their intention to use AI so that the parties can comment on whether that AI is appropriate or not, has the required level of safety to protect confidentiality. So that's an issue.
Yeah, maybe one thought picking up of the very first thing said. I don't know. I think it's kind of interesting that this debate right now is about basically efficiency on one hand, and then like the benefits of humanity on the other hand. But I guess that's really like underlying a very positive image of humanity, maybe in the first place. I guess in our problem right now, the word human factor is pretty often treated on like this misassessment of this email. And I guess there are like errors, just mistakes. But even if we go to questions of morality, we ask ourselves maybe whether there's some bias, whether there's some neutrality. And when we have like the ideal artificial intelligence, let's just say intelligence, then it would be a decision that's purely based on logic, that does not have any bias, that does not have this human factor. And I guess I did not decide on that when I thought it, but I guess that's really the interesting question, whether it is really important to have the human factor, or whether it is not even more just to have a purely logical decision, but it's also not dependent maybe on the quality of the attorneys you can pay and so on. That was just thought to that. Maybe it's not available.
Yeah, no, it's that's a very important point to think about. Yes, go ahead.
I actually want to bring the question back to what was the perceived claimant bias of the AI, because I think that's important here, because ultimately this is a theory, this is going to be experimented on. I think this really boils down to the pure language of logic. It's generally easier to prove an affirmative than it is to disconfirm an affirmative, or more importantly, prove a negative. Now, I'm not just simply saying act as an arbitrator is good enough to replace that pure, the pure structure of logic, especially when you're working within the realms of bounded rationality in a make-believe world. It's always going to say, oh, you could have done more, you could have done better. Because if I say, I have one evidence for X and I have 10 pieces of evidence for not X, it's still going to bias itself towards X. So I think that ultimately it comes down to the engineering of the prompt about, or more importantly, even the training of the model itself, that how does it, what heuristics does it actually include for assessing balance of probabilities? Because ultimately, how arbitrators, work out the balance of probabilities, well, there's no actual mathematical formula they use, right? They just say, I feel that on balance of probabilities, this is more likely than not. We cannot really expect the large language model to do that. It's gonna fall back to the pure mathematical orientation of logic. So I do think that ultimately that without significant headway in both the training and the prompt engineering of arbitration, I think it's generally gonna favor the claimant side over the respondents.
Yeah, and I think that's a very good point to highlight how humans are still crucial, not maybe for doing what we have been doing, but for using tools like this appropriately. And I received a question here on WhatsApp about that. It was something like, what if we change the prompts a little? If we change the prompts, wouldn't that lead to maybe a different decision on the issues? Yeah, could be. Or at least if you ask differently, you may receive more in-depth reasoning for the decision. You may receive different angles of analysis. And so that's all about engineering the prompts appropriately. So,
do we have time for questions from the online audience? Okay, yeah.
But these are the AI questions that I can't answer. Okay. Thanks very much.
Thank you, Mariel.
You guys keep going.
Oh, yeah. Do we have time for these two questions? Okay. Yeah, okay. Okay, shall I read them out? Thank you, Mariel. Okay. I'll
try to be more like
yeah. Okay, all right. There are two questions. The first is about whether you think you can improve the prompt when you ask the AI to make a decision. And so can you improve the prompt to get the GPT to provide more explainability and reveal the grounds for its decision?
Yeah.
So sorry, do you want me to read the second one too?
Yeah, well, just comment. That's the same question I got here on WhatsApp.
Oh, you've got, yeah. Oh, right, okay.
And it's, yeah, definitely. The whole exercise is about trial and error. A lot of AI, maybe almost AI, is trial and error. There is this joke. One of our team members, Douglas Amorim, he is a computer scientist. He's not a lawyer. And he told me this joke about the guy who's looking for a job in AI, and they ask him, 2 + 2, he says 20, 2 + 2, 10, 2 + 2, 8, 2 + 2, 4, you're hired. Because that's how it works, trial and error. And so you try a prompt, it doesn't really give you exactly what you want, you try something a little different. So it can always be improved, and that's the key aspect of doing this. You wanted to say?
And the second question is it illegal in any jurisdiction to use AI in decision making?
Illegal or legal?
Illegal, so not allowed.
I think it would generally, well, as Mariel said, it would generally not be allowed as decision making process. But I'm not aware of any any regulation that would forbid you from using it as a tool in the process of making your own decision, right? And so just as you would use a book, use any other research tool, it's only for instance, you can use it to, as you were saying before, bounce ideas, and then it may come up with an idea that you hadn't thought about, and you will use your human tools to understand that idea and see if it makes sense, and then you will come to your decision with the support of that. But it's still your decision, your human decision, grounded on the way you have to ground any other decision. Yeah,
I guess if parties agree, this dispute should be exclusively decided by whatever system. Why shouldn't that agreement be seen as a valid sort of dispute resolution clause? Yeah, if they say should be decided by arbitration, you should probably say no, that arbitration means humans sitting there. But if they say it should be decided by a machine, then fine, what's the problem? They're free to agree. I think that's partly the problem.
Yeah, there are already these online dispute resolution systems. But the thing is, at least I believe in most jurisdictions, there are some criteria for something to qualify as an arbitral award and be given the legal effect of an arbitral award. And so in some jurisdictions, for instance, you cannot have an award without reasons. And so I'm not aware of any jurisdiction in which arbitrators per se are allowed to be human. And so they are generally thought of as individuals who qualify as individuals, right? But contractually, I don't see any problem for parties to agree on a system that will give them a resolution that they will comply with voluntarily, but they will not be able, there will be no way for the other party to compel them to comply with that decision. But it will not be an enforceable decision. It will be a decision, right? And it will have, at most, in my opinion, contractual value, as it would any other type of agreement. I can just say, let's flip a coin and then decide who is right. That will not be an enforceable decision, but it will be a decision that parties may comply with voluntarily.
Yeah, I think Cesar said it, the main issue would be immediate enforceability. But there is a very interesting case from Mexico, called the Clarence case. It's actually blockchain related. So this is the blockchain platform this was a lease contract. I think it was a very simple contract, and the parties agreed to basically blockchain arbitration.
Just to clarify, it was a regular arbitration award which referenced.
So so that's what I was going to say. To fulfill the human aspect and actually make it an enforceable award, they didn't have that issue there with New York Convention issue because the award was actually rendered in Mexico, so they didn't have to go through the enforceability. But what they did is that they are going to submit to the blockchain arbitration, and they're going to have a sole arbitrator, and then that sole arbitrator was going to confirm and ratify and make it basically something that could look like an award that would be enforceable under the New York Convention. But they didn't have to go that far, so we didn't get the experience with New York Convention jurisprudence.
Yeah, but in theory, you could think of something like that in order to save costs. So like we would agree on a document only administration, we could say we want the arbitrator to use this tool to expedite their thinking about the case, but we still want the arbitrator to overview the results of AI and confirm whether that result is appropriate in their own view. That that might work. Yeah.
Another question from Zoom. Can AI, like the ChatGPT, interrupt legal submissions like a real tribunal could? And can we ensure the confidentiality of the material submitted to the chatbot?
Second question, no, we cannot. As far as I know, it's when you enter material here, you are exposing it to some type of monitoring. It's not this specific model here does not learn from what you put here. So it's not, that's not automatic, but it's not protected either. But you could have a more customized model that would be confidential. And what was the first question again?
Interrupt. Yeah.
If I let Trinity here say everything that she wanted to say, she would be interrupting them all the time. every time I enter anything here, she would immediately give her opinion and ask another question.
Say though, I think the interruption there is like with the speech to text technology, unless you really don't tell them to stop, it's not that they're listening and they suddenly have a question. So the technology would identify the pause and then would stop, and it probably is following the next section that is there, like in the sequence of commands that you gave to them. So I don't know, unless you already specifically told them, and that's obviously like engineering people would know this better, I think they wouldn't have a question unless you told them to have a question specifically, like what do you think is missing in some sort of prompt. I don't think it would interact, and I don't think it can interact the same way as human arbitrators in that regard.
You know, I think, well,
but I don't know.
Yeah, as Luísa said, that's for the engineers, but I think this is all a matter of how you set it up, you know, and how sophisticated the technology is. Here we are dealing with basic off-the-shelf AI and basic free speech to text. I'm sure an expensive, sophisticated system can be configured to say every time there is a 2-second pause, consider that you can intervene, or anytime you think is appropriate, just say something, and it will. It's basically, I think, a matter of setting it up because the technology is there. Yeah, well, any other, you know, one thing that I would like to comment to you, sir, at the back. Hi.
Oh, hello.
Yes. Yeah, so you mentioned something about humans having to judge humans, right? But I think it's interesting that, especially in international arbitration, we are often faced with the fact that we have an arbitrator that has no cultural connection with the facts in place. So you may have, let's say, you may have a Brazilian arbitrator that's resolving a dispute between 2 Asian companies that are under a cultural system. And if you think about law as being part of culture and being part of a set of values that are connected with a certain territory, it's quite questionable for you to think, how come a Brazilian will be able to understand what people from a completely different cultural background mean by things, or how can a Brazilian understand an Asian behavior? Of course, we can say, no, we are all humans. And so there is something that connects all of us. But it's also possible, as in any type of classification, to say we are all humans, but we have different cultures. And so humans from here are not really appropriate to judge humans from there. And so since we are pretty much used to accommodating that situation, we may come to the conclusion that certain types of disputes can be considered suitable for a decision by a non-human, especially because that non-human will be trained on a set of data coming from human experience, right? We will train that machine to consistently, as we were discussing before, consistently decide within a certain set of rules, giving us predictability about the results, efficiency and costs and all that. So if you look at some literature about this, you will often see something like a spectrum in which certain types of disputes will never be adequate for decision by a machine, and others are very adequate, like mass consumer disputes that can be resolved much more efficiently in a predictable manner by a machine.
My question was, like, if you look at today's problems, if you look at today's composition of the Vis Moot, we have a panel of arbitrators comprising of speciality. One was someone specialized in cyber crimes, someone was again specialized in the automotive industry. When we are looking at artificial intelligence, we don't know the background or what's it specialized. So how do we make the choice? How do we select the arbitrator who is an Autobot?
Yeah, go ahead.
We have the necessity to specify ourselves in something, but that's something that the artificial intelligence does not have necessarily. So maybe that's exactly one advantage.
Yeah, definitely. But yeah, to some extent, there could be some kind of explainability of what the data sets are, what's the background of that specific automated system is in order to be a reliable decision maker in a certain field. And so it's pretty much what I showed you here at the beginning.
Yeah, because in our jurisdiction, we have had experiments taking place of having courts, automated courts. And the whole thing is based on predictive technology. Yeah. So the amount of previous predictive technology governs a decision. So if it's not fed with enough data, it's unable to process.
Yeah, in one thing that we haven't discussed that, and it's a whole other discussion, is bias, right? Because if you feed data that contains biases, those biases will be
reflected in the predictive technology.
Yeah, no, but I always think that discussion is quite interesting because in a way it will reproduce the biased behavior that happened before. But on the other hand, it will simply make us face our own biases, right? Because we can pretend that we don't have biases, but then the machine will look at the data and say, this is what you did. I'm not inventing this. And from what you did, you want to make this decision, which is completely biased. And so there is, I think, maybe a bright side to that, which is forcing us to face that reality and maybe overcome, right? And so, of course, we don't have to be happy with our biases, but the fact that there is a machine that will look at all that data, come to a conclusion that we think is unacceptable because it's biased, will force us to recognize that we may have been biased in the past, and we need to fix that now. So I think it's it could be a good aspect of that. If we simply don't settle for that and we do something about it.
And that's what, if it's a tool, it's good.
Yeah.
But if it's made the king, then it's a fool.
Yeah. Yeah, I think we have to go, right?
Yeah.
Lizzie. Yeah, so, well, I thank you so much. It's been a wonderful experience to do all this here with you and have this discussion. I thank again our four wonderful speakers for their participation and their insights. And well, I guess we have come to an end. Thank you.
So much for staying late as well. Can we help with the questionnaire? Maybe do some. Yeah, in a good time.
Yeah.